It's just the exclamation point, right? At the end of the conclusion of the only criminal case that we saw, you and I and America and the world saw, for a man that was facing 4 indictments. 4. And this is the only one. And what is that saying? What was that saying? The poem, what is it like? That's how the world ends, not with a bang, but with a whimper. I may have convoluted it a little bit, but I kind of feel like that's what just happened with this criminal trial that you and I went through, and that a jury sat through 7 weeks of. It just ends with a whimper and not a bang.
Hello, friends, and welcome back to Highly Conflicted, where we unpack the news inside Trump world and what might be coming down next at Mar-a-Lago. We're back on the legal beat this week because Donald Trump is now sentenced in his New York criminal case after being convicted of 34 felony counts of falsifying business records to hide the hush money payment to Stormy Daniels during his 2016 campaign. Trump tried everything he could to get out of being sentenced, in large part because he thought it would be embarrassing and he didn't want to be branded a convicted felon. His lawyers spent the entire week trying to obtain court orders to stop the sentencing and even appealed to the US Supreme Court, which in something of a surprise denied his attempt to stop it taking place in a 5-4 decision. The decision itself was fascinating because Chief Justice John Roberts and Justice Amy Coney Barrett joined the liberal-leaning justices to deny the application, and we will get into that later. So Trump could not avoid the sentencing, and Judge Merchan pulled down the curtain on the trial and completed the legal process in New York, even if he only sentenced Trump to an unconditional discharge, meaning there was no jail, no fines, and no real punishment whatsoever. That leaves one final legal matter outstanding for Trump as he counts down the days to his inauguration on January 20th. Special counsel Jack Smith's report into the federal criminal cases he brought over Trump's efforts to overturn the 2020 election and over his mishandling of classified documents. At this point, the report is still in limbo because, you guessed it, delay tactics from Trump's legal team. To bring you up to speed, Trump's lawyers reviewed a draft version of the report last weekend. They vehemently objected to Smith portraying Trump as having orchestrated criminal conspiracies and immediately sent a letter to Attorney General Merrick Garland asking him to keep it under wraps. And leaning into Judge Cannon's dismissal of the documents case on grounds that Smith was improperly appointed as special counsel because he had not been Senate confirmed, they also argued that Smith should not even be allowed to even write the report in that capacity. At the same time, lawyers for Walt Nauer and Carlos de Oliveira, Trump's former co-defendants in the classified documents case, asked Judge Cannon to issue an emergency order enjoining Smith and the Justice Department from releasing the report because the Justice Department is still trying to resurrect their cases on appeal, and their argument was, well, the release of the report would prejudice them, would poison the jury pool, would release grand jury evidence and materials that should be kept under wraps. Judge Cannon, who obviously has a history of making unusual rulings in Trump's favor, granted that injunction, blocking the release of the report. She also said that injunction would last until 3 days after the 11th Circuit, the appeals court, had ruled on the matter, which they did on Thursday night, and denied the application to continue the stay. This all means that the earliest that Garland can release the report is on Monday, but it's not clear that will happen. There are various legal maneuvers left in play for Trump's lawyers, and by all accounts, including our reporting at The Guardian, that is exactly what's coming down. So to break down all the legal maneuverings this week, I'm joined by MSNBC host and former prosecutor Katie Phang to break down the permutations. Katie, thanks for coming on.
It's been a while. It's good to see you.
It has been a while, but there's lots of drama with the special counsel, so it was perfect timing. But explain this to me. Why does Judge Cannon have jurisdiction to issue an injunction blocking the release of the report, given she dismissed the case and it's on appeal at the 11th Circuit? Because typically isn't what happens is when you dismiss a case, first of all, it's gone. And the fact that it's now appealed takes the power out of the trial court and into the appeals court.
Yeah, so we call it divesting. So she's been divested of jurisdiction because the case is up on appeal at the 11th Circuit. And let's really refine what we're talking about specifically. Judge Cannon, having dismissed the superseding indictment against Trump, Walt Nauta and Carlos de Oliveira on the basis that special counsel Jack Smith was improperly appointed as special counsel. That ruling, that dismissal, is up on appeal in front of the 11th Circuit Court of Appeals. So it's almost like you have to flowchart this out Homeland style, right? Carrie Mathison style, because you have to keep these clean. So that's currently up on appeal in front of the 11th Circuit. That is a Department of Justice appeal, and that applies to basically just Nauta and de Oliveira at this time. Why not Trump? Because special counsel has kind of made, I think through DOJ, a little bit of a concession. And correct me if you think I'm wrong, Hugo, that because you cannot prosecute a sitting president, that case cannot continue, even in an appellate posture. Although I don't recall off the top of my head, Hugo, if there was an actual filing in front of the 11th Circuit to that kind of nuanced point. But anyway, I digress. So while that's up on appeal, the district court, that is Judge Cannon, she doesn't have jurisdiction over the case. She's literally divested of jurisdiction because of the appeal that is taken. So that gets us back to 2 to 3 days ago. Nauta and de Oliveira, with, of course, Trump's help and with Trump chiming in as an amicus, they go to the 11th Circuit after they go to Judge Cannon. And they basically say, we don't want the second volume of special counsel Jack Smith's report released because we don't want that out there. DOJ says, that's fine. We're not going to release it to the public. We're just going to let the chairman and the ranking members of the House and Senate Judiciary Committees be able to see it in camera, meaning you're able to check it out, without the public being able to see it. But Nauta and de Oliveira aren't satisfied with that. They still think it's harmful because there's a pending case, right?
But let's stop there for a second. So Nauta and de Oliveira, and so I'm just going to refer to them generally as the Trump legal team because they're all paid by Trump and they're all under the same joint defense.
And he did an amicus, by the way. He filed an amicus in front of the 11th Circuit.
But why were they able to go to Judge Cannon, first of all, and file this in her court? And number two, why is Judge Cannon then issuing an injunction when technically she doesn't have control of this case anymore?
There's an argument that's being made by them that it doesn't deal with the merits of the case, meaning it doesn't deal with the issues that are per se up on appeal, the special counsel appointment, the inappropriate use of funds for purposes of the special counsel prosecution. The argument being advanced is because these are collateral issues that don't deal with the substance of this case, you can still deal with almost like the management of the case. It's almost like you're dealing in an administrative fashion, although I don't believe that necessarily holds water. And part of the reason that I think it's kind of a reverse action here is because the 11th Circuit, having this emergency motion to stay or block the release that Nauta and de Oliveira was seeking, they rejected that. That's what they did 2 days ago. They said, we're rejecting this. But they being the 11th Circuit, told the DOJ, but you can appeal that temporary injunction that expires on Monday of next week. You can go ahead and you can appeal that. So in some weird way, the 11th Circuit actually made a concession that there is jurisdiction in front of Judge Cannon.
By virtue
because
of
what are you appealing if there was no
order?
Jurisdiction? Would the 11th Circuit just say she doesn't have jurisdiction on this?
Well, that was kind of what I was surprised about from DOJ's side. I was surprised they didn't go to the 11th Circuit and say, we don't even understand why this injunction is even valid, given she has been divested of power over the docket or over the entire case. But I mean, people can quarterback that later. Where we are now is the 11th Circuit has, as you said, denied the emergency motion from Walt Nauta and Carlos de Oliveira.
But they still have a pending motion for injunctive relief in front of Judge Cannon. And so right now, 30 minutes ago, before you and I jumped on this pod, they, as in Nauta and de Oliveira, went back to Judge Cannon and said, we need you to extend your temporary injunction that's going to expire on Monday, which is in 3 days. We need you to extend that until this issue is resolved of us getting an injunction on the release of Volume 2. And by the way, I would also footnote, it involves Volume 1 too. as well, volume 1 as well. Volume 1 of Special Counsel Jack Smith's final report, which dealt with the January 6th insurrection, that's also kind of a part of this whole kind of kit and caboodle. And that's the reason why it's gotten really, really convoluted and very complex. But really, my theory is if you're the DOJ, if you're Merrick Garland, just drop Nauta and De Oliveira. They're going to get pardoned anyway. These are federal offenses. They're going to get pardoned anyway by Donald Trump. Why not just drop them? And this whole concern about, a potential jury being poisoned by what comes out in these reports, which is the defense's argument, then that's out the window. Then you don't have to argue that anymore. And then you should just release the reports to the public wholesale.
Okay, so what you're referring to is the DOJ's current stance in the classified documents case, which is, again, to bring listeners up to speed on what has become a very complex case, is Judge Cannon dismissed it. 11th Circuit, it was the special counsel appealed the dismissal to the 11th Circuit for both Trump and Carlos and Nauta. After Trump won the election, they dropped the appeal with respect to Trump, but kept alive the De Oliveira and Nauta side of it. Ostensibly, as we understand it from our reporting, because they didn't want Judge Cannon's ruling that a special counsel who hasn't been Senate confirmed is illegally appointed. They didn't want that to be the final judgment in the Southern District of Florida. And so they were really concerned about that, just becoming kind of a quasi-precedent there, even though it's not at the circuit.
Do you honestly think there's going to be a special counsel appointed in the next 4 years in a Trump DOJ? That's going to be... I don't understand how that's even going to be a concern.
So what you're saying is if you were the DOJ, you would not take in, at this point, you would not take into consideration the institutional concerns that DOJ has with respect to its special counsel regulations. You would just say, you know what, the gloves are off. Trump won. Trump's going to do whatever he likes anyway. He's going to pardon Walt and Carlos. So we should preemptively get rid of the argument that Walt and Carlos de Oliveira have about, we're still defendants, it's still on appeal, and the release of the report would prejudice us. To preempt that argument, you're just going to say, well, we're going to drop the appeal so there's no more kind of ongoing prejudice, and that way we can get the entire report out. Yes?
I think, but that gets to the crux of what my internal struggles have always been, and have always continued to be when it comes to dealing with the Trump administration. Because are we playing long ball here, or are we just trying to get to the immediate punch? The immediate punch would be dropping the case against Nauta and De Oliveira, releasing the reports, and letting people see right before January 20th, all of what it is. Although, again, here's another necessary caveat. And I mentioned this on social media because I really wanted to manage people's expectations. These are not going to be unredacted reports. People need to realize there are going to be redactions. And these redactions are going to be significant in both reports, less so in the January 6th insurrection report. But remember, there was SIPA, the Classified Information Procedures Act, that was applicable to the classified documents case at Mar-a-Lago in front of Judge Cannon. There were already a lot of redactions and a lot of secrecy that was going into the prosecution of that case. And I don't know if people remember, but there were all those closed door, proceedings that were happening in camera, in chambers where none of us, you and I, were allowed to be. We didn't know what was going on. I mean, there were only certain hearings that were public. So people need to realize a lot of that volume 2, that classified documents report, is going to be redacted. That being said, there could be nuggets that were significant enough, but are they going to change the outcome of an election? The answer is no. So we get back to the criticisms, albeit valid at times, of Attorney General Merrick Garland, which is, was he too married to the institutions? Was he too married to the norms that went out the window with the Donald Trump presidency that created this issue, the slow rolling of the appointment of a special counsel, the failure to act more quickly, all of these criticisms that you hear brewing on social media and other, kind of avenues and places? Is that what Merrick Garland is now debating the merits of? Is it worth it to destroy this idea that you cannot have the proper appointment of a special counsel, which we know is what happened? You had the proper appointment of a special counsel in the classified documents case, as evidenced by other jurisdictions across the United States that have found, and prior case law, that he was, appointed correctly. Do you, to your point, abandon that battle if you abandon the appeal for Walt Nauta and what you're saying is, considering the fact that they're going to get pardoned anyway? So if we're going to get to the same place across the finish line, do you hasten it in some way? And in doing so, you destroy the idea of fighting for the institution of the special counsel's office? Because again, we'll get special counsel, you and I both know, in the next 4 years, but it'll be for the most suspect and bullshit investigations. It'll be,
Okay, but hold on a second,
Hunter Biden stuff. It'll be the Joe Biden stuff, right? It'll be the bullshit that we saw before, and nobody will blink. No one will blink when the special counsel are appointed the same way that Jack Smith got appointed and all of the other special counsel that investigated people like Hunter Biden, right? Nobody is going to blink during the Trump administration on the Republican side about it.
Okay,
so,
but Katie, DOJ thinks in decades, right? Like they think past administrations, and at some point Trump will not be the president. And I guess as
well, depends upon who you talk to, Hugo.
Well, sure, but even leaving Trump aside for a minute, even though Trump is almost certain to pardon Walt and Carlos the moment he takes office, that appeal with respect to the merits of whether or not Jack Smith was illegally appointed or not, that would be taken over and continued by the department.
Look, I agree that there's some type of, DOJ belief that they're playing chess while other people are playing checkers. Again, I'm telling you, that's my internal conflict, right? I'm all for the dispensation of this idea that anybody's going to adhere to a norm or an institution or a rule of law in the next 4 years. But I agree. But I believe that we will have an administration past the second Trump administration in 2028, and it won't be him again. But I
think that's what most people believe, right? But I think this is kind of what it comes down to, right? Is it worth protecting the special counsel regulations as they currently stand and trying to ensure that Judge Cannon's decision, even for posterity on Jack Smith's case, that Jack Smith, and like trying to rebut that assertion that Jack Smith was not properly appointed? Because they may win at the 11th Circuit. If, for all we know, DOJ may continue because it may be in the Trump DOJ's interest as well to keep the special counsel.
But it's going to go to SCOTUS. Do not forget the Clarence Thomas invitation to go to SCOTUS, though, Hugo. So my concern is it's not going to stop at the 11th Circuit. Assuming arguendo, you get the proper result at the 11th Circuit, which is he was as in Jack Smith was properly appointed. We all know that it's going to get appealed to SCOTUS. And then do you then, again, playing chess or four-dimensional chess, right? Or four-dimensional checkers, like, do you then say, okay, I don't even want to create the opportunity to have bad precedent from SCOTUS, a la your conservative majority on the special counsel issue? I mean, I don't know how critical special counsel is to DOJ. I don't know if I'm situated well enough to articulate this in an intelligent fashion for your listeners and your viewers, but I don't really know. Are we throwing the baby out with the bathwater? Have we become a little bit myopic when it comes to this issue of a special counsel? I mean, you could have theoretically
it has not insulated the department.
Donald Trump without special counsel, right?
It has not insulated the department from political criticism.
So do you create a pathway to another Dobbs? Do you create a pathway to another presidential immunity moment?
Or, right? On the flip side, you create a pathway to a new independent counsel resolution passed by Congress, which codifies it in a specific way.
They can do that on their own, but we also know that you have a trifecta right now of power in the GOP, so I don't really see that changing either.
Well, I just want to take a step back for a minute, though, and look at the timeline of what's going to be coming next, because there's really 10 days before Trump's inauguration on January 20, and I think everyone else is very curious as to whether we are even going to get the special counsel report out in that time. So I just want to run through some of the permutations, because this is what you're really good at, and we do this all the time, which is, so let's go through the different scenarios. Okay, so scenario number one is the status quo, which is Cannon doesn't extend the injunction. It expires Sunday night. And
Monday. Well, Sunday night / Monday. Yeah.
Right. So by Monday morning, it would have been it would be fair game for Jack Smith for AG Merrick Garland actually to release the report publicly, or parts of it, whatever, but release the report, shall we say, on Monday. That's one scenario. Yes. Agreed.
Yes. And in order to get there, I don't know if people want to know how the sausage is made. To get there,
nothing can happen though.
Cannon has to not extend She has to deny the motion
Well, she
by
could sit on
reading
it.
the
She's also
tea
very good
leaves,
at that.
I think, from what the 11th Circuit said, but she has to deny the motion for the stay that just got filed, like I said, half an hour ago by Nauta and de Oliveira.
Or she could sit on it and do nothing.
Or
Which she is
she
also
could
very
sit
good
on
at
it
doing.
and do nothing, and the 11th Circuit decision still stands. But in the meantime, we haven't seen any appeal being taken to SCOTUS by Nauta or de Oliveira in any way either.
Okay, so that's scenario number one. So scenario number two is Canon on over the weekend or today or on Monday grants an extension to the injunction blocking the release of the report for God knows how many days. And if she really wanted to be petty, she could do it up until January 19 or January 20 or whatever it is, right?
She could enter a briefing schedule that would extend it to like January 19th or 20th.
And we will both go down to Fort Pierce, and it'll be a fun little trip. One for the capital off. So that could happen. So that's number two. Number three is that not only could that happen, but then we've got this appeal to the 11th Circuit from the Justice Department. So the 11th Circuit could rule anytime next week. Let's assume for argument's sake here that the injunction has been continued by Judge Cannon. And then, I don't know, midway through the week, the 11th Circuit says, you know what, actually, we're going to vacate the injunction completely. But wouldn't that be vacating the first injunction? Would it apply to an extended injunction as well?
So Nauta and de Oliveira are seeking an extension of the first injunction, which was entered a couple of days ago by Judge Cannon. I think it was January 7th.
Is on the first injunction, right? The original one. So if the 11th Circuit vacates the original injunction, would the subsequent extension also be vacated?
Yes. And the reason why is the 11th Circuit telling Nauta and de Oliveira that they are denying the request for the 11th Circuit to put a stay, right, to block the release. They said yesterday, we're not blocking it. They told Jack Smith, you can appeal that injunction from January 7th entered by Judge Cannon. And what did Jack Smith do? He says, I'm appealing it. And hey, by the way, if you don't consider this as an appeal, 11th Circuit, you can also consider this as a petition for writ of mandamus. And so they kind of tried to double label, Jack Smith tried to double label a filing to give the 11th Circuit the opportunity to tell Cannon, you're wrong 20 different ways to Sunday. And so I feel like if the 11th Circuit felt like there was merits to what was currently pending in front of Judge Cannon, you would have seen a stay entered by the 11th Circuit to allow the litigation to move forward on the injunction that was being sought by Nauta and de Oliveira. Does that make sense?
Okay, so that's option, I think, 3. So
I
option
think you're,
4
yeah,
is...
yeah.
Okay, so we're keeping track here. So option 4 is the 11th Circuit vacates the injunction. Trump goes to the Supreme Court. Well, actually, before I get to the Supreme Court appeal side of this,
they could seek an en banc on the 11th Circuit too, by the way.
Well, that's true. They could seek the en banc. But separately, Judge Cannon herself has previously suggested she wants to issue an actual judgment on the merits of the original request to block the release. And she kind of buried that language in the injunction. It said, this injunction is temporary and it's not to be construed as my final judgment on the merits, which I'll be deciding down the line. So in between all of the appeals and the back and forth between the trial court and the appeals court, we could actually get, I don't know if she'll set a briefing schedule. Maybe she'll just decide on paper. She could just decide, I guess, any time in the interim that Jack Smith's report shall not become public, separate and apart from the injunction. And that would also have to be appealed, correct?
Yeah, but that is such a stretch for her. That overreach by her on that is nuts.
Well, she's only got to survive 10 days till Trump becomes president. I mean, and then she's
and then he'll put her on the 11th Circuit,
right.
And then she'll sit with the people that have smacked her down before and told her that
exactly.
She was wrong.
So she's only got to wait till 10 days.
She didn't have to wait that long. The overreach by her on that is just so profoundly wrong. But I mean, she's gotten stuff so profoundly wrong before. To your point, it's almost doesn't make a difference. I would hazard this though. I mean, you could see her do that, although why did she not already do that in her order that she just did 2 days ago, though, right? I mean, in some way, she could have done that. She could have actually spoken on the merits in and of itself and
Well,
entered.
she's a jurist. She likes. Come on, she thinks of herself as an appeals court judge. She likes to take her
Well,
time.
interestingly, as you and I know very well, one of the criticisms she sustained previously when dealing with the Mar-a-Lago case was she never had the trial experience, but she actually had appellate court experience. And so that's
Right.
the other thing why I find it to be surprising that her rulings, when you and I were covering her in the Mar-a-Lago case, were just so bad, because she knows what the appellate issues are when she rules a certain way. And so I was kind of surprised that she did it, but regardless, I'm not also surprised with canon anyway.
So that's option 4, and then option 5 is the SCOTUS one, which our reporting on this is Trump really doesn't want to pull the SCOTUS card until he's got nothing left, but that could be coming down very soon. So I guess what would happen there, and tell me what you think, is the Trump lawyers would go to Thomas, who is the justice.
Yeah, Thomas is the 11th Circuit dude. Yeah.
And then say, hey, we need a emergency kind of stay pending the Supreme Court considering the merits, I guess.
Yeah, but you know what's kind of curious about all this, and I think that's getting lost in the translation, because there is so much back and forth and tree killing that's happening when it comes to these filings. The people that truly have the due process issues, it's not Donald Trump, it's Nauta and De Oliveira. And in fairness to them, if the DOJ wants to continue to prosecute them, I see the merit in the argument that they do not want the poisoning of a potential jury pool to happen by a potential jury pool reading about all of their quote unquote alleged, I'll put that in quotes, wrongdoing.
But the report,
That
that's a good point, because the report doesn't say alleged, as far as we can tell, based on the original filings. Apparently, one of the complaints of the Trump lawyers is that the language is very conclusatory. It basically says Trump orchestrated criminal conspiracies. It leaves out the alleged kind of, hedging moments, and that was also one of the complaints, but yes.
No, and I'm glad that you bring that up, because, I mean, nobody could ever confuse me for being a fan of Trump, Nauta, or De Oliveira, but I'm a fan of the law, and I am a fan of due process, because we all want due process. It doesn't make a difference who we are, how rich, how poor, although frankly, the double standard in the justice system is pretty glaringly obvious these days. But I don't take umbrage with this idea that they deserve to be protected. Their due process rights, but Trump doesn't have any due process rights unless he's saying, I mean, he does have due process rights, but in this instance, they're not at prejudice or they're not at risk in any way, unless he's saying, oh yeah, when I get prosecuted in 4 years, when, they come back to prosecute me, like that's when it's going to hurt me. Because I always want to speak in practical terms. I kind of feel like people get frustrated these days with the waxings and the musings, of our legal conversations, not you and I per se, but just generally. But the practical implications of the release of those reports, again, I go back to something we just talked about a few minutes ago. What is the practical implication? It's not like they're going to go to the Oval Office with a shovel and put his ass on the shovel and move him out of the Oval Office if this comes out. I mean, it's not going to change that outcome. And again, we get back to the basic fundamentals of the criticisms of Garland's not moving quickly enough per se on this. So I guess we'll just have to wait and see. But of course, we're on a Friday night. No action's really going to be taken, I think, in the next 48 hours. But seeing how the injunction is theoretically due to expire on Monday, I will see something coming from Canon imminently, and we'll post it and let people know.
I think that's all. I agree with all of that. I think all of that is very accurate. I just wanted to give you also a final say on the sentencing, because that was the other legal matter that was still active with respect to Trump as he prepares to take office. He's obviously been sentenced now. But I think the most interesting thing to me was how the Supreme Court did not intervene at the 11th hour to block the sentencing. And Chief Justice Roberts and Justice Amy Coney Barrett ultimately ended up siding with the liberal-leaning justices on the court and allowed the sentencing to go ahead. And I'm curious, just as a final point, if you were surprised by that.
So a lot of people got excited about the idea that Amy Coney Barrett and John Roberts sided with the liberal justices. I didn't get as excited, and let me tell you why. If you read the opinion/order as it was released by SCOTUS, part of the reason why they didn't enter the stay to block Donald Trump from being sentenced is because they basically said he wasn't going to get a sentence. If there had been the very real threat of incarceration or even a probationary term, I don't know if you would have seen Amy Coney Barrett and John Roberts siding with the liberal justices, Hugo. I don't know if you would have seen that happen. I think there was the notation within the decision itself, I believe, that said, because there's no real threat of a disruption to the presidency and all that other stuff. And that was a Sotomayor, I believe. I think she wrote it, right?
Right. I think that's right. Yeah.
So I think they basically said, again, we're getting back to practical implications. Maybe that's the title of today's episode for your pod. The practical implications of a sentence was the fact you got no sentence. And I've said this on my show, and I've said this in other places. I think it's bullshit. And I still laud the work of Judge Merchan. You and I also witnessed it in real time. I laud the work of the Manhattan DA's office for standing up to the bully in the playground. But the absence of teeth and the absence of consequence sends the worst message. And I will, stand by this. I think you can only praise them so far until you have to say that Merchan kind of bent over a little bit backwards in his reasoning, saying, that you can't disrupt the presidency because he has to serve the American people.
Yeah, you could have
the
fined
man
Trump.
Was found guilty for 34 felonies, each of which carried a sentencing from 1 1/3 years to 4 years in prison. Even if he never got to jail, Hugo, he would have been sentenced to probation in any other situation. And it was just such, it was so oxymoronic to me to say this was not an extraordinary case when the doors closed to the courtroom, as Judge Merchan announced today, because he was treated the same as any other criminal defendant. And yet I'm now going to pronounce an unconditional discharge, which no other defendant would have gotten in that courthouse. It troubles me to no end. I may not be actively practicing law anymore, but I'm not that so far removed from not only criminal cases, but civil cases. Civil cases, of course, can still be quote unquote prosecuted or pursued against a sitting president. But, there's a difference between a civil case and a criminal case. He committed crimes. And the other noteworthy thing to Hugo, before I'll stop speaking is, and I wrote this down because it bothered me so much. I think this kind of escaped some people today because, and of course the courtroom was, closed to the public, as in like the people didn't get to watch it or hear it. But the pre-sentencing investigation report was given to both sides. And the probation officer noted that the defendant sees himself as above the law and won't accept responsibility for his actions. I mean, that is, if you were any other criminal defendant and that's what you said to your probation officer who was interviewing you for your PSI,
you would get a
that
really
would
bad
actually
sentence.
lead to you getting just launched even more when it comes to sentencing. So the fact that he could say it just so blatantly and grossly disrespectfully, and to end up, it's not even a slap on the wrist. A slap on the wrist would have been probation, right? That would have been the slap on the wrist. And so,
well, that's actually kind of funny, and maybe that's maybe the note to leave it on, because
the slap on the wrist.
Well, no. In that Judge Merchan proclaiming before the sentencing that he was likely going to sentence Trump to an unconditional discharge, meaning no jail, no fines, allowed them to get to sentencing because, to your point, the Supreme Court looked at that and said, you're not going to be prejudiced, Mr. Trump, and you're not going to have your kind of, it's not going to distract from the transition of the presidency. So as a result of that, they got there, but as a result of that, it also allowed Trump to kind of thumb his nose at the justice system and say, well, I'm clearly not going to get jail anyway, and so I'm going to be completely unrestrained. And including when I deliver my remarks via video, by Microsoft Teams, actually, to Judge Merchan during sentencing.
He didn't even have to show up, Hugo.
Yeah.
He didn't even have to show up. He could stay at Mar-a-Lago and not even have to show up. I mean, Merchan at the least could have made him show up. Just show up. It was 45 minutes in the end? Not even? just make him show up for that. Like, at least get us that much farther along this idea that everybody's treated the same. But alas, that didn't happen. Again, it's not a criticism, I guess, per se, of Judge Marchand or the DA's office. They did the best that they could do with the cards that were dealt. It's just the exclamation point, right? At the end of the conclusion of the only criminal case that we saw, you and I and America and the world saw, for a man that was facing 4 indictments. 4. And this is the only one. And what is that saying? What was that saying? The poem, what is it like? That's how the world ends, not with a bang, but with a whimper. I may have convoluted it a little bit, but I kind of feel like that's what just happened with this criminal trial that you and I went through, and that a jury sat through 7 weeks of. It just ends with a whimper and not a bang.
Well, it was very anticlimactic, and we are still yet to see even if the special counsel report will become public in any form. So we will continue to wait for that. But Katie, thanks for coming on.
Thank you.
I'm Hugo Lowell, a senior political correspondent at The Guardian. Special thanks to our guest today, Katie Phang.